Good morning, everyone. I'm calling Civil Appeal number 1 of 2020, Wanda and Pedro against the Attorney General and Minister of Legal Affairs. Before my Lord Sir Christopher Clark, President, and Justices of Appeal, Dame Elizabeth Gloucester and Justice Anthony Smelly. Mr. Cameron Hill is appearing on behalf of the applicant, Ms. Pedro, and Mr. Brian Moodie is appearing on behalf of the Crown Respondent.
Mr. Hill, it's nice to see you, but rather late in the day. These proceedings are supposed to start at 9 o'clock your time, and it's now nearly past.
I apologize for that. I had diarised 10 o'clock, and I can only apologize. Indeed, I have experienced quite a bit of difficulty in the administrative department with this. There's been quite a few errors on my part, and I can only apologize for them slightly en masse. It's not been an easy job, and if I've inconvenienced your lordships, then I apologize for that.
Right. Well, okay. Now I can take a slightly unusual course. Just tell you our sitting arrangements. The first session before a break is usually 3 hours, but we find that sitting for a long period by Zoom is wearisome, and we will take a break in about 2 hours' time. Secondly, if during the course of the hearing you can't hear us, sometimes the Zoom has funny characteristics and mutes, you need to wave or make some indication, because we don't know that you can't hear us. And if you can't hear us, we probably can't hear you. Now, the next matter is this, and I'm now addressing Mr. Moodie.
Yes.
We have read all the papers in this case, some of which are not that easy to follow. But our current position, subject to submissions to the parties, is that we incline strongly to the view that if permission is needed to appeal, either by way of leave or by way of an extension of time, or both, then it should be given, certainly so far as an extension of time is concerned. But more importantly, it seems to us that the learned registrar lacked jurisdiction to sit as an acting justice because she had not sworn the oath required by the Constitution. She'd sworn an oath as registrar, not the oath which the Constitution requires. And it seems to us that it's not possible to apply the presumption that all is presumed correct until it's proved otherwise. Because if she had sworn the oath, it seems inconceivable that there wouldn't be a copy of it, and Government House doesn't have a copy of it. And if that is so, it seems to us that she was not competent, I don't mean that offensively, I mean that in its technical term, to sit as an acting justice. It is true that she could sit as registrar, and it may be that in other circumstances, if she purported to sit as an acting justice, but could have sat as registrar, that it would nevertheless be, one could proceed upon the basis that she had jurisdiction to do that which she had to do. If she had sat as a registrar, the right of appeal would be to a judge of the Supreme Court, for which leave would not be required, not to this court. And it doesn't seem to us that we can at one and the same time proceed upon the basis that she should be treated as sitting as registrar, but that the appeal from her decision is an appeal to this court, for which leave is required, and not an appeal to the Supreme Court, for which leave is not required.
Go on. I was just going to simply say that the appeal from the registrar's ruling is also not strictly speaking an appeal as it is in the Court of Appeal, is in fact a rehearing, and you have there's an awful lot more scope for bringing all of the arguments, and the restrictions of questions of law and fact don't come up as well.
Yeah,
I apologize for interrupting.
No, don't. No, that's a perfectly reasonable point. And the trouble is that if what I've just been saying and what Mr. Hill has added to is right, and subject to what I shall say hereafter, there is no, if that approach be right, there's no great point in going through the merits of an appeal, which we are not, which is from what is in effect a non-decision. Sorry, that's rather a mouthful for you to have to swallow at the very beginning of the proceedings, but it seems to us, because that is a semi-provisional view that we have reached, that we ought to proceed by A, telling you, and B, inviting you before Mr. Hill to say anything, to say what you wish, not anything, but make any submissions that you wish as to why we may have reached a wrong semi-provisional view.
Good morning, my lords and my lady. I think the provisional view that the court has adopted is correct. Certainly, if Ms. Wheatley purported to sit as registrar, then the appeal should be directly to the Supreme Court. In terms of your preliminary view that she would have lacked jurisdiction to sit as a judge to hear the strikeout application, indeed, that would essentially be an end to the matter today, because it would mean certainly the matter would have to be remitted to the Supreme Court for a fresh hearing. So I think if we take either position, there is not much utility in proceeding to go through the merits today. As you will note from our submissions, we concentrated primarily on the issue of leave.
Yes.
And we certainly accept that your lordships would have weighed some of the issues raised by that. And I'm happy for your indication of where you're minded to go in that respect. But certainly I think with respect to either position, today's proceeding, we would have to concede that today's proceeding would be unlikely to go ahead or to serve any purpose if it did.
Well, Mr. Moodie, that's extremely helpful. And I think on that basis, what we are going to do is to say that the proceedings were in effect in front of an acting judge who wasn't, because he hadn't taken the necessary oath, and that the matter must be remitted to the Supreme Court, and it would probably be better that it be determined by somebody other than the registrar, because that will avoid any question about apprehension of bias or anything of the kind. However, that leaves the question as to what directions we should give. And what I'm now saying is primarily directed at Mr. Hill, and I'll say quite a bit before inviting him to respond, if I may. It's common ground, or it's accepted, that the pleadings will need amendment. We know how difficult things can be for litigants in person, but the present position is frankly unacceptable. What we have is the writ, and that contains on the second page what is said to be the plaintiff's claim, which simply sets out a number of sections of a number of acts. There's then a document headed Damages Caused by Social Workers of Child and Family Services, which has 22 paragraphs, which are on any view prolix and difficult to follow. There is then a document headed Damages Caused by Magistrates as follows, which seems to be otiose since the claim against any of the magistrates has been removed. So the pleadings do not fulfill the function which they are intended to fulfill, which is A, to set out what cause of action is relied on, and B, to set out the facts but not the evidence which are relied upon as giving rise to the cause of action. That is problem number one. Problem number two is that the defense as filed does not actually plead the Limitation Act. And the Limitation Act needs to be pleaded. Three, we of course follow that in the skeleton submissions, reliance produced very late in the day, reliance was placed on the Limitation Act, and that it is now said in various different ways that there is a response to, or there is an answer to the Limitation Act contentions, which is not manifestly unlikely, not manifestly absurd, or will obviously fail. But I must tell you that I have, speaking for myself, spent quite a time trying to work out what exactly, firstly, there's a problem in applying the Limitation Act when you don't know what is the cause of action that is relied upon, or what is the date upon which the cause of action must have accrued, though that date would appear to be in about 2009. But leaving that aside, in relation to the application of the limitation or the response to the limitation period, one of the matters, as I think is relied upon, is the provision in section 12 that in a case for personal injuries, the limitation period is 6 years from the date from which the cause of action accrued or from the date of knowledge. The registrar refers to this in her ruling, though for some reason not clear to me, she doesn't actually set out in her ruling what is the definition of knowledge in section 15 of the Limitation Act, nor do any of the parties before us do so. But under that heading, the date, it would be necessary to know, and I'm looking at section 15, when Miss Pedro knew that the injury in question was significant and that it was attributable in whole or in part to the act or omission which is alleged to constitute negligence, nuisance, or breach of duty, and the identity of the defendant. And the Act makes plain that knowledge that any acts or omissions did or did not, as a matter of law, involve negligence, nuisance, or breach of duty is irrelevant. So it would be necessary to understand, A, what is the injury, B, when it occurred, and C, whether it is said, well, when it is said that she became aware that the injury was attributable to the acts of which she complains, whether or not she knew that they involved a breach of duty. That's one item. There's also reference to fraudulent concealment. And as I speak, it is wholly unclear to me from the voluminous documents, A, whether the cause of action can be properly described as based on fraud, because it's not clear to me what the cause of action is anyway. And it's not clear to me what, if anything, is the fact relevant to the cause of action that has been deliberately concealed, and when the plaintiff is said to have discovered it, or could with reasonable diligence have discovered it. And then lastly, insofar as reliance is placed upon section 34, there are a series of considerations of which the learned registrar referred specifically to one, but not the others. So effectively, the state of the pleadings is, to use a technical term, a mess.
President, if I might also add the question of consent,
yeah,
as is manifest on the record from the orders of the magistrates court, the last of which appears to have been the 8th of January 2010, and how it is that they would be plaintiff says that her case is tenable, notwithstanding the existence of those orders.
All of these matters to which I have referred and to which Justice Smelly has just referred need intelligible explanation in an intelligible pleading. And we have it in mind to order that this matter should be remitted to the Supreme Court to be determined by a justice of the Supreme Court, to order that there must be an amendment, firstly, an amendment of the pleading, and to explain, insofar as it's necessary to do, what the pleading must do. Because if what happens is that another version of the pleading, as voluminous and difficult to follow as the present is produced, it seems to us highly unlikely that the judge of the Supreme Court will allow the amendment to be made. Since also we know, and it's blindingly obvious, that the defense is going to include either you haven't got a cause of action, and as I say, without knowing precisely what the cause of action is, it's difficult to know how far that goes. But the defense is undoubtedly going to be the Limitation Act. It seems to us, though this is debatable, that in those circumstances, as well as setting out properly the position in relation to the matters that I have spoken of, including how one gets round the fact that the last three orders on any view were orders, or on their face, were reached by consent, that the sensible course would be for the particular statement of claim, A, to set out the matters to which I have referred, but B, to set out the basis upon which it is said that the limitation period is inapplicable. I know that the normal arrangement is that the plaintiff relies on his cause of action, properly pleaded. The defense, amongst other things, pleads the Limitation Act, and the plaintiff in reply says, well, the Limitation Act doesn't work for the following reasons. But there's intrinsically no reason why the plaintiff cannot, in his statement of claim, set out the basis upon which he says that the Limitation Act does not apply. And in the light of the position that we've currently reached, it seems to me that it would be sensible for that to be done rather than waiting for a formalistic pleading which says the Limitation Act applies, followed by the answer to the Limitation Act in the reply. Now, Mr. Hill, that's rather a long 10-minute introduction, but I hope that it makes plain what we are concerned about and the course that we are minded to take.
I've been instructed in this only to a limited extent, only for the appeal. I had suggested that I might prepare for this appeal something resembling a draft statement of claim, which set out how the cause of action was formulated. That did not meet entirely with the favor of the clerk, and that's for quite understandable reasons, because it's not the Court of Appeal which concerns itself with the sustainability of the cause of action. And I think that he was concerned about timing because we only had the morning at that time. It is clear, as your lordship says, that the statement of claim, as I'll call it, the amalgamation of a number of documents is difficult to follow and is, on the face of it, based upon facts which occurred well over 6 years ago. The cause of action which Ms. Pedro asserts at this stage is a cause of action in personal injury.
Sorry, that's not a cause of action. That's a damage.
Well, negligence. In negligence, she says, well, it would be misfeasance in a public office. You have to get up to us. This is Three Rivers case.
Just a moment. Forgive me.
Yes.
She says she has suffered personal injury. That is not itself a cause of action.
No.
You've just mentioned A, negligence, and B, misfeasance in a public office. The two are not the same.
No, quite. This will be a Three Rivers case.
Misfeasance in a public office.
Yes. And we were relying on unlawful acts of various social workers.
What
and
sort
I've seen evidence that would support a pleading which Well, it is my belief sitting here today that this is a case which is capable, a pleading is capable of mapping out a claim under the principle set out in the Three Rivers case.
Mm.
That misfeasance gave rise to an injury. That injury is described in the documents that we have. That injury is psychiatric in nature, and the nature of the injury will require the production of expert evidence. Since I have been involved, Ms. Pedro has consulted with that expert, and the evidence that I have to me now would allow me, in compliance with the usual principles of my ethical code, to raise to say that a psychiatric injury has been suffered. Damages flow from that. And the next question you come along to is, when did Ms. Pedro know, or ought to have known, that she had suffered such an injury, and that injury was relatable to the unlawful acts of the various social workers? Because as your lordship says, it's not a question of negligence. She has to know that there was acts which gets her up to the point of the Three Rivers case.
Well, I'm not sure that's right. Section 15, which everybody seems most unwilling to cite, says that knowledge is when you know that the injury was significant, that it was attributable in whole or in part to the act or omission which is alleged to constitute, amongst other things, a breach of duty, and the identity of the defendant.
Yeah.
And knowledge that any acts or omissions did or did not, as a matter of law, involve negligence, nuisance, or breach of duty is irrelevant. So it's not necessary to show, you can't succeed in saying the limitation period begins later because I didn't know that the defendant was negligent, as a matter of law, negligent, guilty of nuisance or breach of duty. The question under section 12 is when you knew that the injury of which you complain was A, significant, and B, attributable in whole or in part to the matters of which you complain.
Yes, I might have made myself, I probably didn't make myself properly understood. The acts that she discovered, and which she says she couldn't have discovered until when she did discover them, she says she discovered in 2016. And that is when the pleadings, and don't get me wrong, there are limitation issues with this case. The pleader will have to be very careful to ensure that the facts that he's aware of, well, if it's me, that the facts that I have available are properly sustained by evidence and that I can properly plead them. We accept that there are limitation issues, and we shall see how far we get down the road. It may well be that she can't get there, but there is, from what I've seen so far, something that would sustain a case. I'm sure that when we get to that point, there will be another application to strike out the claim, and it will be based first on the question of limitation, and secondly, on the question of misfeasance. So there will actually be an application under the first head of Order 18, Rule 19.
Yeah.
There is no disclosable cause of action, but that can only be worked out properly when the pleadings have been got into a shape where a judge could make a proper finding of when the time started to run, when the facts were known to the plaintiff, that the injury was significant, et cetera, et cetera, et cetera. And from what I have from our experts so far, the dates do work, the type of injury does work, and the damages that flow from it. It is, I don't think I need to add much to that. I believe that there's a sustainable misfeasance claim in what occurred to Ms. Pedro and her family.
Well, no useful purpose is to be served by an extended discussion of the potential problems that Ms. Pedro faces, but they are substantial. And in our ruling, we will point out with such precision as we can what needs to be done in any pleading. But you are instructed and we're grateful to for your assistance for this appeal. It's not clear as we speak whether you will continue to be instructed in the future. Part of what I was saying a moment ago was to give notice that if what is produced by way of an amendment is as diffuse and in part baffling as the present pleadings, even if that is produced by Miss Pedro alone, there is a realistic prospect that the Supreme Court judge will not allow the amendment to be made upon the basis that it's unworkable.
And that is how I imagine that is in fact how the whole thing will come to be determined, because Ms. Pedro, whether through me or through some other counsel or herself, will need to make an application. Does she need to make an application for leave? Yes, because she'll be adding a cause of action, so she'll need to make an application for leave. And that application for leave, I'm sure the amendments will be attacked on the basis that even if allowed, they don't disclose the cause of action.
Well,
so the two applications will meet in the middle, as it were.
Sorry, what are you referring to as
the application for leave to amend, which
Yes.
will have to come, will
Yes.
meet an application to strike out, because there's no point allowing the amendments if they themselves do not disclose a cause of action.
Yes. Well, there'll be a resistance to the leave to amend.
Yes, that's what I'm saying.
Or you can call it to strike out if you like, but I mean.
Yes, well, both, and the question will be determined. I've made clear to Ms. Pedro that the pleadings as they stand are not acceptable.
Yeah.
I have made clear to her that she has she has what appears to me prima facie grounds for bringing the claim, and that I've advised her that she would be sensible to get counsel with some experience in these matters, because this is not an easy case to get onto the train tracks. Now, whether or not I can do it for her and we can come to some arrangement is a matter that I'll deal with her, and we shall see where that goes. But she's aware of the issues. I've raised them as clearly as I can with her, the difficulties that she may well face. The pleadings will need to be as succinct as possible, and deal. Your Lordship has said that you would like them dealt with in the statement of claim in the first instance, but they can certainly be dealt with in a reply, which is where I thought they were going. But I will make sure she understands that as clearly as needs be.
I think the point is, Mr. Hill, that it is already clear that you have a limitation problem.
Yes.
And so for my part, I entirely agree. There's no reason why she shouldn't address that in the first instance in her pleadings.
I should take that direction. I heard his Lordship a moment ago, and I hear your Lordship now. I'm sure that it's touched upon.
My Lord President has indicated there's no point in engaging in a debate now on what the pleadings might look like, but I think it might be useful to indicate that even before you get to the limitation issues, Ms. Pedro will have to address how she pleads the question of consent. How does she say that she's not bound by what appear to have been orders made by her consent? That is apparent. It is not apparent how she would address that.
But well, she does say, and I spoke with her about this the other day. Pardon me. She does say that the council who consented to the initial supervision order exceeded her authority, and that's why that retainer, such that it was terminated. But I will deal with how all of this unfolded. The facts are complex.
That is not clear from the papers we have. And so as a matter of pleading below, for the purpose of any useful directions that you might give, it was important to know what she'll be saying in that regard.
Very well.
Because with respect, my lord, her remedy may very well be against what she alleges to be inefficient counsel.
Mr. Hill, have you seen the last three orders chronologically?
Yes.
Because
yes, I have. Yes.
Because the pre-penultimate one is dated the 29th of October 2019, which records that by consent, an earlier order of the earlier orders of the 3rd of June.
That was 2009.
2009, sorry, and 27th of October 2009 were confirmed.
Yes.
On the 3rd of November, the order records that the court, with the consent of the plaintiff, made an indefinite supervision order, with the father having care and control and her having liberal access. And on the 8th of January, the order confirms that Ms. Pedro withdrew her application for custody, care and control, and by consent, Mr. Jones Sr. and her would have joint custody, and by consent, Mr. Jones Sr. was to have care and control. So there are 3 orders which record that they were with her consent in circumstances where she was legally represented.
Yes,
Seems quite a hurdle to get round.
yes.
Right.
Absolutely. For the moment, she says that there was an excess of authority, that her ability to intervene properly in the proceedings was impaired by the nature of her injuries, and we will see where that goes. But the question of counsel's consent in court is one that does arise occasionally. It meets with a number of hurdles. She will make her. I will attempt to assist her to get the case made as well as she can. I will serve that in accordance with the directions we're likely to get from the court below at some stage. And if my learned friend is not satisfied that it gives rise to a sustainable cause of action, then we will deal with that as lawyers do and have done for years.
You say directions of the court below, you're likely to get some directions from the court above.
That's perfectly all right as well. But I presume someone's going to fix some time limits for the filing of this the application to amend. I presume that we'll need to get back in front of the judge to get some directions about the filing of evidence in relation to the heads under sub-rule B and C, and that's of order 18 rule 19. And the train will then go beyond its tracks and will come to journey's end, wherever that may be in due course.
Yes, well, I mean, I think the process should be that you file a proper statement of claim, which includes the points we've mentioned, and B, the limitation issues. The defense will then have to determine whether or not to object to the amendment or to seek to strike out the proceedings under a new application, either on the basis they disclose no reasonable cause of action or that they're frivolous, vexatious, or an abuse of the process of the court.
That seems sensible. I thought that I'd in fact reverted to that type of procedure in my submissions.
Yeah. Right. Well, I don't think that we can, subject to the views of my colleagues, take matters any further at the moment, unless there are further observations that either of you would wish to make.
I did have one, and I think it's only fair. It's a personal matter of sorts. During the course of being instructed by Ms. Pedro and my initial discussions with Mr. Coelho, I allowed my language to become intemperate, and I wanted to record my apology for that language to Mr. Coelho, and to the extent that the court was aware of it, to the court as well. There will be a lot of things blamed on COVID-19 in the coming months. Apparently, it does have an effect on your cognitions. My wife certainly tells me it had an effect on mine. I had the disease, and apparently I became very angry very quickly, and it appears that Mr. Coelho was on the receiving end. And I wanted to record my apology for that. He neither deserved nor had any reason to expect that he would receive an email in quite those terms.
Well, thank you very much for that. I hope you're over COVID-19.
I am. It takes a long time, though. It's not a nice thing to have.
No, I can well imagine that. Right. Now, the only other
comment to make,
yes, of course,
which is it might be helpful if the parties could agree the question of costs of this hearing of an incidental to the appeal, or whether there are any submissions which either counsel would like to make in relation to the costs.
I imagine there will be some submissions. I was going to come to that in a moment. The costs that have been thrown away, as it were, do not really fall on the parties at all, and there may be a question as to whether or not the judicial department might have some liability or some role to play in meeting the costs that have been occasioned by the failure to produce a duly appointed judge for the hearing. There are a couple of cases on the point, and the relevance of Article 6 rights and how they impact. Indeed, there's a medicament, your lordships will see in the authorities I provided on bias, there's a medicament, I call it the medicaments case. There's another case on costs in that case, which deals with some of these points. So if perhaps did your ladyship have any initial thoughts as to how the costs should be dealt with?
No, I'd like to hear submissions on it.
Yes, well, the question's quite complex, and I wasn't going to be ready to do it today. But should we perhaps consider coming back at the next session?
No, certainly not.
At the end of this one?
If your lordships would permit me, I would have thought that Mr. Hill would perhaps wish to hear my position.
Yes.
And in fact, in contemplating this matter, I have certainly from my own extent, was going to refer the court to one, the deficiencies in the pleadings, which formed a part of my outline submissions, which I believe were compounded by the failure of counsel to meet the deadline set by the court, certainly in terms of outline submissions and other deadline issues, such as the reconstructed exhibit, which was only provided today. However, I believe in the circumstances, having regard to the view of the court on jurisdiction in terms of Miss Wheatley, and with deference to the fact that Miss Pedro was a litigant in person, I would suggest that the appropriate order for the court to consider would be no orders to costs. I think that would be fair in the circumstances. For the Crown, as you know, our costs are theoretical. This is part of the job we do. And so the time spent is really for our account. And certainly the directions given by the court has assisted both parties, I would say, in either getting the claim on proper footing and certainly dealing with the real issues once they're identified. So I think this would be an appropriate case for the court to say there should be no orders to costs in this matter, certainly not against the defendant. And that is my position.
Thank you. What do you say we should do, Mr. Hill?
Well, but the position is that the question of the effectiveness of the appointment of Ms. Wheatley to act as an assistant justice was raised immediately. In fact, it was raised before I was instructed, because I had been speaking to Ms. Pedro before we agreed that I would assist her. It could have been agreed to by either the Crown, because I didn't have any way of obtaining the information as to whether or not she'd actually been sworn. It wasn't in my possession. I have gone on to my simple, it appeared to me difficult to have occurred in another matter. Anyway, and all of the costs of preparing all of this hearing could have been avoided had that been conceded, the failure of the appointment or the ineffectiveness of the appointment. As to the court below, Ms. Pedro did appear as a litigant in person. There are rules which apply to a litigant in person. And what should have occurred, well, I don't want to get into the substance of the ruling, but my learned friend very properly and decently, I must say, suggested to the learned assistant justice, or the registrar, Ms. Wheatley, that the matter should be adjourned to allow at least some affidavit evidence in support of the pleadings to be lodged, and indeed perhaps for the pleadings to be cleaned up at that stage. And the whole hearing proceeded on the basis of the insistence of the judge. but the cost of those will be dealt with in accordance with the rules which apply to litigants in person. But I have had to prepare because I had no idea what your lordship's planned to do this morning. And in the absence of any concession, even in principle, that if she hadn't been sworn, her appointment would be ineffective, I've had to prepare for the entirety of the hearing of the whole 9 grounds. And that would be deeply, I mean, I put in quite a lot of time trying to work out what's going on. I've had to get the whole case up from scratch. I've had to look into the causes of action, the questions of limitation. It's been, and I've had to do that relatively in extremis because I had nothing to do with it until I think it was early April or late March. And it's certainly not the case that this is one which no order should be made. She has been successful, and she's been successful on the ground headed ground number 1.
For clarification, is Mr. Hill contending that the Crown was aware that Ms. Wheatley was not properly appointed before Ms. Wheatley put in her affidavit?
I'm not sure whether or not the order for cost should be made against them. The order for cost today it should be made against the intended respondent, because the intended respondent could have conceded the point. I produced an email from Ms. Wheatley. Well, I produced an email from Ms. Wheatley in which she said exactly what she said in her affidavit, that she hadn't been sworn in as a justice.
When you,
I think that in relatively short order.
I'm getting very confused. You say the cost should be made against the intended respondent. You use that expression on the basis that it's not the actual respondent until
well, the respondent now, if you're the respondent then, because we haven't. It should be made against the Attorney General.
Well, I'm also confused about that, because the judgment below was against the Department of Child and Family Services.
To be fair, we took the point with Mr. Coelho, my Lord President, that the Department of Child and Family Services has no legal personality. And so despite
the fact that your defense said the proper defendant is the Department of Child and Family Services.
Well, yes, and again, I would indicate that our difficulties in the defense had to do with the nature of the pleadings, and that was not a point that we took or noticed until further on in the proceedings when the discussions were had with Mr. Coelho.
Right.
And at that point, we accepted that the proper defendant in any action relating to the Department of Child and Family Services should be the Attorney General.
Right.
So on that basis, if I might, is the Attorney General now to be regarded as the respondent?
I would submit so, because the Department of Child and Family Services has no legal personality. The other issue, which I think
it will also be a consequence of Section 14 of the Crown Proceedings Act.
Certainly, my Lord. The other issue is who are the other defendants, because one of the issues dealt with by Ms. Wheatley is the standing of the other named defendants. And the record should reflect that Ms. Pedro, the appellant, accepted that the other defendants were not properly joined, having regard to the nature of the case. And certainly she consented, based on my recollection, to removing those other defendants. Now, if they remain on the record as parties, then they need to be served. There's no indication that they were ever served with initiating process. They certainly were not served with any documents relating to the appeal and have been given no rights of audience in their own. So I think those are issues which should be dealt with at some point.
Okay, so I mean, we can, there's no difficulty in us, is there, ordering or declaring that the proper defendant is the Attorney General, and any application to amend the statement of claim must be against the Attorney General.
Indeed.
I think that would be correct.
I should, in candor, I should indicate that I'm considering whether or not the director himself needs to be named, and not the department. But there will be, the Attorney General will be one defendant. There's a possibility that the director also is named. He's usually named.
Well, wait a moment. This is increasingly muddled. Everything gets muddled in this case. Is it right that Ms. Pedro accepts that she has no claim against the magistrates and Miss Smith and the individual social workers?
Yes, I believe that that's a concession that she made below.
Yes, that's what I understand. So we
Yes.
can say in our judgment that the proper defendant is the attorney. It's accepted, as opposed to the Department of Child and Family Services, and is
Yeah.
accepted that the others are not proper defendants.
That is my understanding.
Right. Right. Now, if you want to join the director,
Then I'll need leave.
yes, and you may face different limitation problems in relation to him.
Indeed.
Hmm.
Yes, there's a great deal of caginess has to go on at this stage, but
Oh.
yes, I'm alive to those issues.
Yeah. I don't know why you need to join the director if you've got an attorney general who can pay any damages, but that's
Yes, right. That's all of these things will have to go into the washing machine and
yes. But
yes.
anyway, I think let me just, so that there's no confusion or no remaining confusion. I think you say that you should be entitled to your costs of this appeal against the proper defendant, which is the Attorney General. Is that
Correct.
right or wrong?
Yes.
Okay. Right. Is there anything else that we need to consider?
Not that I can think
I
of.
don't think I have anything further that's useful to add. I think all the
Right,
points have
okay.
been canvassed.
Thank you very much. Well, we're very grateful to the council, and subject to any views of my colleagues, we'll terminate the session and deliver our ruling in due course.
Thank you very much, my Lord President.
I'm grateful.
Yeah,
Right.
President, should we go to the breakout room?
Yes, please. Yes, yes.